Dear students, GPS CLAT Academy at Gyanodaya, a senior secondary school at Sikar, supports its students in their CLAT preparation. We have started a lecture series which will be delivered to you on a daily basis on YouTube.
This is a very interesting article. Basically, it elucidates what we all know, that writ jurisdiction is available only against the states. This is how an authority or a state must be there in order the writ jurisdiction of the constitution to prevail against them. This is required under Article 12 of the Constitution. I'll just show you Article 12 of the Constitution, share with you. And says that here it is. In this part, unless the context otherwise requires, the state includes the government and Parliament of India, government and legislature of each state, and all local and other authorities within India or under the control of government of India. So what is a state? This is defined in this. And Article 12 is the North Star, the pole star, which gives us direction as to the entities against which the writ jurisdiction of the court would apply. So these entities are government, parliament, government of the state assembly or legislature, or local authorities and other authorities. So these are basically now the courts have expanded the horizons of the writ jurisdiction and try to rope in private entities also. And in doing so, the court emphasizes on public functionality tests. There must be a public function which must be discharged by the entity. If the entity is doing merely a commercial work, then it will not be will not become eligible for or subject to writ jurisdiction. But if the functionality discharges a public function, then only it will become amenable to writ jurisdiction. Now, interestingly, um, the article basically talks about the timing is critical here. Even if when the petition was instituted, the authority was recognized as a state. There was an authority, or there was some public department which was run by the government. So it was state for the purposes of Article 12 and for the purposes of fundamental rights. Subsequently, if the nature changes, nature undergoes a change, then in that case, if the public functionality test would apply, and if the public functions are being discharged, if they have an element of public interest apart from the commercial angle, it should not be a purely commercial kind of thing. Then in that case, even if when the writ was instituted, and finally when the stage comes to dispose the writ by a judgment, the material time is the later stage when the case has to be disposed of. At that time, what is the prevailing situation? Whether the functionality test, public functionality test, would apply to an otherwise private entity or not? That is what. Now, in this case, you must have noticed that various hospitals are being run by government schemes. Under government schemes, for example, the ECHS is a famous scheme, Employee Contributory Health Scheme, which is available for defense members. Now, its ambit is also expanded, I guess. So, the private hospitals, you can choose any private hospital, and the government will foot the bill. That is the mediclaim that the government provides to its former employees. So that is now in this case the government. Now, running a hospital is a purely commercial function. It has nothing to do with, though you can say that it is a public purpose which is being served because the hospital is dealing with public health. But that may be too far-fetched an argument. There must be some statutory involvement, or there must be some other public element which must be there. Otherwise, what is the difference between a private hospital which is not run on a government scheme and a private hospital which is run on a government scheme? It's very difficult to make out the two. Only difference is that in one case the payer is the state government, in another case the payer, the person who pays, is basically the private individual. That is the only difference. Otherwise, both hospitals are the same. Both hospitals have a very high standard of service delivery. Both hospitals follow the same protocols. Both hospitals have the same or similar billing structures. So there is nothing public about it. What is the additional public element which has come in? How is a government, how is a private hospital running an RHGS scheme, or for that matter, an Haryana government scheme for Haryana government employees, or for army employees, ex-servicemen or officers, the employee contributory health scheme, whichever it is how these are all commercial functions which have been made over to private entities because they seem to perform better than government institutions. That is the whole idea behind it. And running government facilities is more expensive than rather paying the government entities for their services. So from those considerations, it's interesting that there is a difference between Article 32 and Article 226. Article 32 is wider in its scope compared to Article 32. In Article 32, you can have a writ petition, but in Article 226, you can enforce statutory rights also. Other interests it talks about. Though the court adds a caveat that in you can't so expensively interpret Article 226 as to be completely divorced from the reality of writ essentially being available against the state, against the government, and not against private entities. There must be a government involvement, substantial government involvement. There must be some substantial public element. Only then the ambit of Article 26 would basically include something which is not included in Article 32. So basically, the writ jurisdiction which you have been studying in your class 11th and 12th, that writ jurisdiction, how it operationalizes, this is what is explained in this article as to when a writ is maintainable, when a writ is not maintainable, what are the requirements that the body must be a government body, it must be a state, it must be falling under Article 12, and if it is a private body, in what circumstances a writ may be maintained against a private entity. So all these things are highlighted. At the tail of the article, it is also highlighted as to what is the law of limitations, some basic principle of this is a very interesting part of this thing, because the law of limitation basically means that you have a certain time period within which you can agitate disputes. You can't agitate disputes as and when you please. You can't have something like 10 years of gap after which you are entertaining a dispute. That is not feasible. You must have usually the limitation period for filing a civil suit is 3 years. So in the under the Consumer Protection Act, I think it is 2 years. So if you have even 1 day of delay after 2 years of the cause of action first arising, then in that case you will not be able to maintain your suit, and the court will be dismissing your suit. But here in this case, since the employees were agitating their claims before a wrong forum, therefore the court relied on Section 14 of the Limitation Act, which basically provides that if you are agitating your claim in a wrong forum, then the court will grant you the liberty to approach the correct forum, right? So that the limitation will not run. The limitation period which you have spent, suppose the dispute was originated in 1986, then the suit should have been filed latest by 1989, within 3 years. But you are engaged in the writ petition, and suppose 1986 you filed the writ petition, or 1987 you filed the writ petition. That is, originally you filed it within the period of limitation. You did not file it after 10 years. You filed it within 3 years, which is a period of limitation for filing a suit. So But in the writ limitation, before in the writ when it was before it was taken up for final disposal by the High Court, a period of 10 years lapses. So you have 13 years, and 13 years limitation is not available. So section provides that if you are agitating your case in a different forum, you can still maintain it. The limitation won't apply, right? Chaliye. What is? Let us take up the questions now. If the public function is not there, then the rate won't be maintainable. And here it is not stated that the private corporation which has taken over the operation, it is not described what kind of public function was being discharged by the, yes. A private hospital takes over the administration of a government health scheme. Now, this is already done. Even if private hospital has been given the duty to provide ECHS treatment to patients, what difference does it make? It's just a commercial hospital function. Chaliye, come to 83rd. Let us go to the next one. Loan function, whether or not the government wants to, the private bank wants to give a loan, or whether in their judgment they think that the loan should not be granted. The court is not going to tell the bank give the loan to this person or give the loan to that person. That is, the court is not competent to do all that. Only the bank can make an assessment of to who to give the loan and to whose loan application should be denied. So that is hardly court's function. They will not do it unless there is a element of discrimination or prohibited something which is prohibited by the Constitution Part 3. Then the loan bank will not come in. Chaliye, I think it's question number 2084. Yes, he has to now approach a tribunal. He can maintain, or he has to file a civil suit. So the summary jurisdiction in writ is not available to him. We have already seen this because it is a private company now. It is no longer a state. Chaliye, come to 85. So this is on limitation. If your suit is time barred, but you are pursuing a remedy in a court without jurisdiction, then you can be given benefit of limitation. So that kind of. Come to the next passage, please. Yes. So basically, this is a very interesting article, and this article basically highlights what lies in the political domain and what lies in the legal domain. What I mean to say is that everything in a way lies in the political domain, because you have authorized a government. You have elected a government, given them the mandate to rule. And then you have also distributed the powers between the union government and the state government. And then they can exercise their executive power. And executive power may be exercised not necessarily in accordance with law. Executive power may be there even when there is no law. Many instances are there when the government exercises the power. For example, in making a bridge, there may be no law on the subject, and still the government does it. It is not constrained by the law. The constraint comes later. Government has the executive authority, and that is and the Supreme Court has said that the powers of the government within the legislative domain, list 1, list 2, list 3, these are plenipotentiary. There are full powers to the government to take whatever action they want to take. Now, where does the law come in? The law comes in when the political leaders are not able to manage, then they make a law on the subject. For example, IPC. Now, if you put it, Indian Penal Code, if you put this kind of function to the politicians, it will become very difficult for them to function, because they can't go on settling disputes. It's impossible for them to work. And besides, they are subject to pulls and pressures. The decisions, what kind of decisions will come, depends on which political constituency. So it will lead to a chaos. So what do? When they can't manage it, when the political leaders or political authorities are not in a position to manage things in the exercise of executive powers of the government, then they make a law. There are so many laws. There are so many laws. There are maybe more than 2,500 central statutes on, and they forget about the local statutes. There are so many laws. So whenever there is a there is a requirement of a law. The law is made, and when the law is made, to that extent, the moment the law is made, it becomes a limited government. What does the Constitution does? What the Constitution does is it limits the power of the government to take actions which are contrary to the constitutional limits prescribed in the Constitution. So this is law also has a similar function. Law tends to limit the powers of government. It also tends to limit the powers of citizens in a certain way, duties of the citizen also in a certain way. So the function of law is basically to provide checks on exercise of executive powers in appropriate cases. And land acquisition cases are a patent example of that. Now, the liberties which are there of individuals, liberties are a matter of procedure. The, the right to notice is such a powerful right that it can have the executive action of the state turned turtle. It can have it thrown out. The right to notice. Notice comprises of what? That it should adequately communicate the grounds for which the action is being taken. It should give sufficient time. For example, 15 to 30 days time has to be given to the person whose house is being demolished. If you don't give, then your demolition becomes illegal. And you may be liable for payment of compensation. So you can see the procedure. Why Article 21? I'll just refer to Article 21. What is there in these procedures? Somebody may tell you, what is there? What is there? It is only a matter of procedure. But then you will understand when you see, once again, you visit Article 21, you see what the Constitution provides and how all this is institutionalized. If you see this one, no person shall be deprived of his life or personal property except according to procedure prescribed by law. Procedure prescribed by law. Now they have said everything in this very small thing. They have brought in the entire constitutional jurisprudence by merely saying procedure prescribed by law. That's it. So these procedures at times become overwhelming. These procedures at times are really very difficult to follow. And that is why these procedures are important, because these procedures are basically imposing limitations on the arbitrariness that can easily seep into executive actions. So here the acquisition process, number one is who is to acquire. That is a question under the law. As who is competent to acquire, whether it is a state government who is acquired or whether it is a municipal corporation which can acquire. Now a petitioner whose land is being acquired, he is very curious to get this acquisition thing set aside. And if he gets hold of this procedure, that the procedure was not followed, that is enough to set the entire acquisition aside. So see the power, see the potency of these procedures. Then ultimately everything boils down to whatever may be the philosophy, whatever may be the scheme of statutory scheme that you have built up. Ultimately, it will be tested on the touchstone of the procedures, and it can be appended there. It can be turned turtle there. So you can understand how important what kind of importance is acquired by these procedures. Then you already know what are the procedures. Principles of natural justice are the procedures. Nobody can act as a judge in his own cause. The right to hearing has to be there. You have already seen the ambit of the right to hearing. You can't have a post-decisional hearing. This is what the Supreme Court says in the environmental. Only the other day we have done that. That post-decisional hearing, we don't think that the post-decisional hearing is a correct kind of hearing. You have to give a pre-decisional hearing. That means the hearing must precede the decision. If you give a post-decisional hearing, as we have seen, I hope you will remember in the environmental passage the other day we were discussing that the post-decisional hearing was given. There is no such thing as a post-decisional hearing. The Supreme Court says in the environmental cases, you have to have an environmental impact assessment properly done, and we will not allow you to dilute the provisions of the environment impact assessment by giving a post-decisional hearing, because you will be biased in favor of your own decision and you will not take a proper decision. Therefore, the right to be heard includes a right to have a pre-decisional hearing. The right to reasoned decision. Once again, it is only a procedure, reasoned decision. But then it is a very potent procedure. Because the moment you put something on a piece of paper, arbitrariness is immediately put to a check. So once again, it is a procedure. But how potent is this procedure? The reasons have to be communicated. Reasons have to be recorded. Reasons have to be communicated. If the reasons are not there, it is so powerful that the Chief Justice of India, who has written an arbitration award, his decision itself is struck down by the Singapore High Court. We have done this. We have done this in one of the class. So powerful a principle. Reasoned decision. The reason was not reason. It was all prejudice. It was all prejudice because it was a copy-paste job. You did not apply your mind independently to what you are doing. Then, of course, the power of eminent domain. We have discussed the power of eminent domain, and we have also discussed in what circumstances the power of eminent domain and to what purpose, to what ends the power of eminent domain can be exercised. The power of eminent domain is there with the government. The government can do the acquisition. Not a problem. We are not contesting your power for eminent domain. Not a problem. But then it is only eminent domain. You have to exercise it for a particular purpose. And it can't be your private purpose. It has to be a public purpose. So that is, if you remember, I'm sure you will remember that we have done this article on public domain, eminent domain. If you remember that, I'm sure you'll remember that. Right to restitution or fair compensation. Now, this is a sticking point because Article 19, right to 19(1)(f), in which the right to property was enshrined, that was deleted by the government in the that was deleted, and since it was deleted, right to property was deleted by the parliament, and Article 300A was inserted in the constitution in its presence. I'll just quickly refer to Article 300A of the Constitution. What it says. This is what it says. It has come down from a constitutional fundamental right to a constitutional right. Nevertheless, it is there, and it is here. Article 308 says no person shall be deprived of property save by authority of law. So once again, the mischief is that you can't deprive anyone of save by authority of law. So there must be a law in existence. If the law is not there in existence, if the executive rule is there, if bylaw is there, circular is there, or some notification is there, it will not be saved. There must be some law in existence. So you see, deprivation, if you want to deprive somebody of property, the notification must be under a law. It can't be something like a law. Once again, the mischief is sought to be remedied by reference to Article 21 of the Constitution. Then he says the right to efficient and expeditious process. The process must not only be there, but you have to complete the entire process within a particular time span. And of course, you have to acquire the physical possession also. So, and then they mention Article 300A, that the 300A the court refers to, and he says that the save by authority of law. The authority of law, that means not the executive authority, but the authority of law. Law means enacted law by the parliament or by the state assembly or by say local authority. But the enacted law must be there. If the elected law is not there, then in that case your acquisition may be liable to be set aside. Just like in this case, on a reading of the law, the court concluded that it is the state government which has the power. It is not the municipal commissioner who has the power. You see the technicality, but the technicality is of very, very great value to the petitioner whose land is being acquired. He is thrilled that entire process is gone. Now it's all right. The whole thing will start once over again. And in the 10 years that have gone in between, my land has acquired a value which is five times or 2 times or 3 times the value that was there at the original time. So, it makes a hell lot of difference to the petitioners. Now, having done that, let us now come to the questions. Government agency initiates acquisition of private land, inform the landowner about the acquisition proceedings, and issue an acquisition order. Claim violation of his constitutional rights. Is the claim valid? So he says the claim is valid. How the claim is valid? Informs the landowner about the requirement of notice is not met. You have to have a written notice. It can't be mere providing information. Verbal information is not sufficient. Write it down on a piece of paper and give it to him. so that he can challenge it if required. All right. Please come to question number 88. Now you see here the mischief is that he wants to build luxury apartments. If you are going to build luxury apartment, does it qualify for eminent domain? You can't do that. I require this land because some business friend of mine wants to make a villa here. No, nothing. You can't abuse the powers of acquisition which have been conferred on you for a particular public purpose. Those powers will have to exercise only for a public purpose. Farmer's land is acquired for highway expansion. Not satisfied with the compensation. He claims that market value. Unfortunately, that is the sticking point. Market value need not be paid. Where is it written? Market value need not be paid, but what needs to be paid? Then what needs to be paid is a fair value and keeping in consideration the market value. This is what the article says. Therefore, this becomes, yes, it is here. Right to restitution or fair compensation. Monetary compensation, rehabilitation, some others. Compensation is integral. Compensation must be adequate. I'm not saying it should not be, it should be inadequate. They are saying that it must be arrived keeping in mind the market value. They are not saying that it should be the market value. They are only saying it should be keeping in mind the market value. It can't widely diverge from the market value. But that is not the same thing as keeping in mind monetary compensation, rehabilitation, similar other means. So this is slightly dicey part because if you don't give the proper market value to a person for his property, you are taking away the sustenance of that person. So that is a sticky part. So farmer's claim is not likely to succeed, unfortunately. So because law is like that. The landowner's property was marked for acquisition 5 years ago, but the government has yet to complete the process. You know that delay in acquisition the entire acquisition can be invalidated. You have already said that in your presentations. So we need not dwell on that any further. So please come to the next and do it very quickly because I don't want to keep you into this. It's already 9 o'clock. It will interfere with your. Quickly do the 2 articles which are remaining very fast. I think you have summarized the main points, so I can take over. Look, this is a very illuminating article on what constitutes how bail has to be treated. Now, first of all, let us understand what is the rationale of the bail. Now, when somebody is accused of an offense, then the steps that follow are that an FIR is lodged. After the FIR is lodged, the accused has to seek the bail. First, the police grants the bail in an appropriate case, if the case is like that. And if the police doesn't have the powers to grant the bail, then the court will grant the bail. That is how it goes. Many times, police also has the powers, concurrent powers to grant the bail, and in lesser offences, the police can very well accept the bail. And then the accused is referred to the court, and he applies for the bail once again before the court, and he is enlarged on bail. And in case of serious offences or offences in which it is certain that the accused has committed the crime, then in that case bail is usually deferred until such time as the investigation is complete or until such time as at least a part of the sentence is already undergone, like 1/3 imprisonment and things like that. Now, why the concept of bail is required? Look, our legal system is premised on the on the on the basis that the every accused is to be treated as innocent until he is proved guilty. So, an accused, if the moment an accusation is made and you put him behind the bars, that kind of fundamental tenet of our criminal law is falsified. It doesn't work. Even this is also one of the very high legal principles, very high stature legal principles that let 1,000 accused go scot-free, but a single innocent individual should not be punished. So legal morality is very high morality. So what is required in the light of such legal morality? What we require is a robust procedure for bail. Now, what does the court do? What does the magistrate do when he has to grant the bail? He has to see the likelihood of having committed the offense. he has to see what preliminary evidences have been presented to him. If it is a case in which there is no way in which the accused could have committed the offense, he will set him free. He will set him on bail pending trial. And if he feels that no, the offense has been committed by the accused, in a preliminary, if he comes to a conclusion that yes, there is something, he will allow time to the investigation to be completed, and he will defer the bail. If he sees that yes, there are reasons to believe that he may tamper with the witnesses. For example, he's a high-ranking official of the government, or he's a political leader and holds considerable sway in the local area. Then the court will defer the grant of bail until such time as the investigation is complete. And even subsequently, the bail may be denied if the court is of the view that he may misuse his authority to tamper with the evidences or to influence the witnesses. And in such circumstances, the bail may still be denied. The only guiding star before the court in such cases is the interest of justice should be served. That is also that is a very valuable kind of concept. So when it comes, interest of justice should be served. Now, when it comes actually to grant a bail, uh, like it is like you go to the magistrate and he says bail granted, bail denied, bail granted, bail denied. So the bail is a very that kind of thing. Sometimes the judges say conscience does not permit, so I will not grant the bail. So you can see this requires a lot of what we call as you don't need to write detailed bail denial orders or bail granting orders. Small orders are there, and these are very important. These are valuable for the people who are seeking justice, or the accused who is arraigned before the court and who believes that he has been falsely arraigned before the court. So this becomes very important. It is the magistrate's duty to ensure that an innocent individual is not kept behind the bars for a prolonged period of time or for any period of time. And at the same time, he has to ensure that a person who is certain to be guilty of a serious crime does not go scot-free on bail. So he has to balance those people who have committed offences, who are certain to have committed offences, and there is damning evidence against them. And in that case, bail may be deferred. But in those cases where it is unlikely that the accused has committed an offense, then it would basically be an encroachment on their liberty if the bail is denied to them. So it is a balancing act. You have to very carefully uh, decide on the basis of whatever evidence is in front of you. Here, the article highlights that conditions which are preposterous or absurd should not be made a part of the bail orders, and the conditions should be such that they serve the interest of justice. But as I said, that is a very malleable concept. Nevertheless, court cases give us a certain amount of guidance on what can be the interest of justice and what may not be in the interest of justice. For example, a court order which says that look, you have to serve. Uh, you have to serve in the Gurudwara for 1 week. You have to wash the dishes in the Gurudwara for 1 week. That means, as a condition of the bail order, that means you already decided that he is guilty, and you are subjecting him to such conditions. So this kind of condition cannot be imposed. You can't say that now. Look, you will have to go and provide labor at rupees 1 per day. No, that is also absolutely absurd kind of bail conditions. So these bail conditions may not be imposed, though there is not much guidance in the law as to what could probably be the conditions. Nevertheless, court judgments do offer us significant amount of guidance in this behalf. And the fundamental rights of the accused are very important. The accused does not stand to lose all his fundamental rights merely because there is an allegation against him. The allegation may be unfounded, and it has to be proved beyond reasonable doubt. So Article 21 kicks in, and it says that no one shall be denied the right to life and personal liberty if say by authority of law, except according to the procedure prescribed by law. So the procedure will have to be gone into. The trial is the procedure, and the trial should not become the punishment. In bail cases, the trial itself is the punishment. That should not happen. In order to prevent such cases of patent injustice, the bail is a valuable right that the law gives. Then it also balances. The article also seems to be discussing a court judgment wherein the right to privacy vis-a-vis the bail has also been discussed. And in the right to privacy, basically all those bail conditions which are absolutely intruding upon the privacy of the accused, those such bail conditions are liable for striking down, and those which provide occasional surveillance, occasional monitoring, those are likely to survive the test of interest of justice. So this is what the article talks about. Now let us have a look at what the questions are. So if we have a look at the questions, a Sessions Court grants bail to the accused charged under NDPS Act 1985. However, the bail order includes conditions requiring the accused to report periodical. Now, this is reporting periodically. This may not be objected to the nearest police station. Is the order legally sound? So, if it is NDPS and periodical reporting is being required, it is deemed to be reasonable. It's not that you have to come every day to the police station. They are not saying that. Right? Please come to the next one. An individual granted bail is found influencing witness. This is a crime. It can lead to cancellation of bail. What is the bail application will be allowed? The cancellation of bail application will be allowed if you do that. Tampering with evidences, tampering with witnesses, influencing witnesses, all this is not allowed. Particularly on bail. Bail will be cancelled and you will be taken back in custody. A high court restrains the accused from moving out of the country. They impose condition that accused must share his location with law enforcement whenever asked to do so. So there are checks in the order. It is not a absolutely wide, unchecked order that they are, all the time you have to keep sharing your location. They are not saying that. Whenever you are asked to do so, just to ascertain whether you are complying with the court order or not, you are required to share your location. So that there is nothing wrong with that. Then the court grants bail to an accused charged under NDPS, but includes a condition requiring him to work voluntarily for government agencies every weekend. But this will be not be in the interest of justice, because requiring discharge of voluntary work means somewhere in the mind of the judge there is a presumption of guilt, and the presumption of guilt is not permitted except in case of money laundering statutes and in some other statutes. The presumption of guilt is raised and the accused has to rebut the presumption of guilt. It is turned around. It is turned around to say that it is for the accused to prove his innocence. So those are difficult situations. Come to the next passage, please. So basically, this article is a continuation of the earlier article, but the focus is different. Here, the focus is on a very troubling issue in our society, and that is most of these bail cases involve poor prisoners. Now that the status, the financial status should not come in the way of seeking justice. So that is why the entire legal aid program has been started by the government of India. That if you don't have the funds, you can still approach the courts and seek legal aid. And the legal aid committee will examine whether you have a case to prosecute or defend. Then in that case, they will provide you services of a lawyer, and you can either prosecute or defend yourself. So that is the philosophy behind. But the problem is this bail is not amenable to that benign intervention of the law, because here the problem is that these people come from weaker sections of the society, and their poverty comes in the way of seeking competent legal advice and being set large on bail. And the problem also is aggravated when you have this prisonization, what the author says. Prisonization comes about means a prisoner very quickly loses his identity, and he becomes a cog in the wheel. So this is very dangerous. For the first time in the 1970s, a very glaring problem came to the notice of the Apex Court, and an enterprising lawyer brought it to the Apex Court's attention. that several under trial prisoners were languishing in jails in Bihar for years at end. That was the Hussain Ara bunch of cases, series of cases in which this was brought before the court, apex court, and the apex court immediately issued the directions for their immediate release. When you give directions for their immediate release, the second problem is that you have to ensure that they attend the trial. Now, when they have to attend the trial, you have to require a bond, and they don't have the money to pay for the bond also. So the problem is not at only at one stage. The problem is multiple problems. Then what do you do? Then the court says that release them on the personal bond. Don't put them to financial securities and all that, because they may not be in a position to furnish the financial security. If they don't furnish the financial security, you'll again put them in the jail. So this aggravates the problem. And in some cases, the situation was so glaring that the person has completed the entire sentence, and not only completed the entire sentence, even thereafter also, beyond the completion of the entire sentence. For example, somebody is accused of theft. You can put him into jail only for 3 years. You can't put him into jail for 30 years. But there have been cases when people have been treated like that. And the Hussain Ara Khatun bunch of cases basically sensitized the court to the predicament of the Indian legal system in the bail system, the kind of problem it was creating, and how the poorer sections of the society were basically uh, taken out of the bit of the part 3 of the constitution. And in that context, the Supreme Court issued directions for their immediate release and examination all over the country of such cases. And the law was formed up in that regard. Now, second thing, we have already discussed that the bail as a concept, on what kind of fundamental premises it rests. And we have already seen that the bail basically is on the premise that you are innocent until you are proved guilty. And the bail, unless there are firm grounds to believe into your guilt and the charge is very serious, like murder and all that, serious offenses are there, then you cannot be denied the bail. You have a right to seek the bail. So the Supreme Court has enlarged the scope of the bail and says that even in case of special enactments where the burden of proof is reversed, it is put on the accused. There too, if the likelihood of trial completing within a reasonable span of time is not there, is absent, there also you have to enlarge the people on the bail. And we know the cases of some of the AAP leaders, Aam Aadmi Party leaders, who have been granted bail by the apex court, but their provisions have been under such, their accusations have been under such offences in which the presumption of burden of proof is shifted, right? So this is what the article talks about. Now let us handle the questions. Nina is charged with theft under 379. Charge is serious. The prosecution has failed to prove her guilt. The trial is still at an early stage. She applies for bail to decide her bail application. So the trial is still at an early stage. Prosecution has failed to prove her guilt. In that case, 379 IPC, the charge is non-bailable. So in this case, what will you do as a magistrate? You will grant the bail or you will disallow the bail application? This should be, application is to be disallowed is incorrect. You have to allow it, because charge is serious is no ground. And theft is how serious a charge is theft. So the prosecution has failed to prove her guilt. No, trial is still at an early stage. So the trial will take a long time. You have to allow it. Sorry, I'll correct it. It is wrongly marked. Yes. Next, 100% correct. So don't bother. Come to the 98. That speedy trial means the special courts means speedy trial. And at least their performance should be better than the regular courts. So that kind of. Okay. So we have finished the legal reasoning part of it. Now, logical reasoning may be a little far-fetched because it is already 10 o'clock, and your tomorrow you come prepared with the logical reasoning part so that tomorrow we may finish this. All right.
The lecture series revolves around discussion of mock papers. You can request us for the concerned mock papers. If you intend to join us in our daily discussions, you are most welcome.